Have you ever heard that famous expression that a grand jury can indict a ham sandwich? Well, the same applies for lawsuits too, especially class action lawsuits. You can pretty much sue anybody over anything, even a ham sandwich if you want. But class action lawsuits also can allege serious criminal behavior, such as in the case of Boeing and Southwest Airlines being accused of an organized crime type RICO conspiracy and price-fixing scheme during the MAX crisis. But how many of you were even aware that Boeing and Southwest Airlines were being sued for conspiracy to defraud Boeing MAX passengers by overcharging them for MAX tickets, even though Boeing and Southwest knew the Boeing MAX was dangerous, and thus by selling tickets to fly on a MAX at any price was, quote, an overcharge? Not only that, but the lawsuit alleged a conspiracy between Boeing and Southwest existed, citing the RICO statute usually reserved for organized crime. But that's exactly what the passengers alleged. Boeing and Southwest were an organized criminal organization. Sounds like something I might have said in previous videos. But we're not talking about me. Anyway, these 11 plaintiffs actually got the go-ahead in the Texas District Court for the lawsuit to move forward. But then, of course, Boeing and Southwest appealed the decision to a federal appeals court where it had been languishing since 2019. Well, the appeals court has finally made their decision on whether Boeing and Southwest are the Sopranos of the aviation world, or this lawsuit was just a ham sandwich. I've got the bizarre details on this lawsuit, and I'll tell you what the court decided, and if this was finally the time that Boeing would have to answer for the MAX. That's next on Maximus. Greetings, Legal Eagles, Maximus here. Welcome to another edition of Maximus Aviation Law and Order. So back in July of 2019, 11 plaintiffs filed a class action lawsuit in United States District Court for the Eastern District of Texas. However, before you can actually proceed with a class action lawsuit, it first must be certified by the court. So that was the reason they were before the District Court in Texas. So let's head over to the Maximus Law Library and take a look at the filing. The purpose of the suit by the 11 named plaintiffs was that they sought to represent everyone, yes, everyone in the world, who purchased or would purchase a ticket for travel on Southwest or American Airlines MAX jets between August 29, 2017 and March 13, 2019. These 11 plaintiffs alleged that the MAX passengers overpaid for their airplane tickets. The actual prices of the tickets that were purchased as a result of the misrepresentations by Southwest and Boeing about the safety of the MAX aircraft were significantly higher than the value of what those tickets should have actually been worth. So then what should the value of those tickets have been? Well, I'm glad you asked, because the lawsuit alleges that the price for those tickets should have been zero. That's right, zero, zip, nada, nothing. Now don't get me wrong, it's not that I don't agree that the prices should have been zero, especially after knowing what we know now about how Boeing built the MAX, but strictly legally speaking, that's a really hard argument to make. But of course, Southwest and Boeing immediately asked the Texas District Court to dismiss his ridiculous charges, to which the court agreed with Boeing and Southwest. The District Court dismissed the plaintiffs' claims for lack of standing, to the extent that they alleged that if the passengers and future passengers had known the MAX 8 was fatally defective, the passengers would never have purchased a ticket in the first place. So the court held that because this theory sought to recover for a risk of physical injury that never materialized to any of the passengers or future passengers in this lawsuit, and none of them were involved in a crash, that the court didn't buy their argument and threw those charges out. So then if Boeing and Southwest won the dismissal, why did they appeal to federal court? Well, that's because the lower court's ruling didn't end their entire case, because the lower court did agree that the plaintiffs received an economic injury, in fact sufficient to support going forward with the case. Specifically, the plaintiff's allegation that Boeing and Southwest's fraudulent actions allowed them to overcharge the passengers for their tickets. The district court said if it had not been for Boeing and Southwest's scheme to conceal the MAX 8 safety defects, that demand for tickets on routes flying the MAX 8 would have decreased along with the price of those tickets. So the theory goes the passengers paid a fraud-induced overcharge at the time they bought their tickets, and the court granted the passengers' suit to recover the amount of that overcharge. So the district court held that the plaintiffs could proceed on that theory and that theory alone. So in 2019, the district court granted the motion and certified 4 classes. 1. Violations of the RICO Act. 2. Concealment and misrepresentation. 3. Unjust enrichment. And 4. Negligence covering nearly 200 million ticket purchases. It was at that point that Boeing asked the higher federal court of appeals in Louisiana to stay the lower court's decision pending the appeal Boeing and Southwest were going to file. And that stay was granted in 2019 until the appeal had been decided. And that brings us up to date, because that appeal was finally decided 2 days before Thanksgiving last week in 2022, 3 years later. On November 22, 2022, the U.S. Fifth Circuit Court of Appeals in New Orleans rejected the 2019 lawsuit. In a unanimous 3-0 decision citing the plaintiff's failure to prove plausible harm or injury, physically or financially, the case was sent back down to the lower Texas District Court with instructions to dismiss the case. The appellate judge who wrote the opinion said that the plaintiffs in the class action lawsuit alleged that Boeing and Southwest Airlines defrauded them by, among other things, concealing a serious safety defect in the Boeing 737 MAX 8 aircraft. The district court certified 4 classes encompassing those who purchased approximately 200 million airline tickets for flights that were flown or could have been flown on a MAX 8. But the appeals court said the plaintiffs have not plausibly alleged that any class member suffered either physical or economic injury from Boeing and Southwest's alleged fraud. The decision said that therefore the plaintiffs lack standing, so they said that we reverse and remand this case back to the lower court with instructions to dismiss. So, agreeing with me that this case was a ham sandwich to begin with, in his written decision the appellate judge explains just how bizarre the price-fixing claims clearly were. He said first, the plaintiffs assumed that if there were widespread public knowledge of the MCAS defect, that Southwest and American Airlines would have just continued offering the same MAX 8 flights, but with a price discount to compensate for the heightened risk that the passengers would die. Yeah, sounds kinda nuts, right? The judge basically said that that's an insane assumption. However, the judge stated that the more plausible inference or result would have actually been that Southwest and American Airlines would have offered 0 MAX 8 flights until the defect could be fixed. Secondarily, the judge wrote that the plaintiffs assumed that the FAA would have actually permitted airlines to keep flying the dangerous MAX 8, even with full knowledge of the MCAS defect. This inference is even more implausible than the first, he said. That's because in reality, after the public learned the full extent of the risk caused by the MCAS defect, regulators worldwide grounded the MAX 8. The judge said that the FAA, for example, grounded the MAX 8 for 20 months. So in all likelihood, if the FAA had learned the full extent of the MCAS defect sooner, which plaintiffs contend would have happened if it were not for Boeing and Southwest's alleged fraud, then the MAX 8 would have been pulled from plaintiffs' routes. But again, the court said that that would have caused ticket prices to go up, not down, because of the reduced aircraft supply in Southwest and American's fleet. So in the end, the judge summed it up like this. He said the plaintiffs have not plausibly alleged any concrete injury. They conceitedly have suffered no physical harm. They have offered no plausible theory of economic harm. He said the plaintiffs complained of a past risk of physical injury to which they were allegedly exposed because of the defendant's fraud, but because that risk never materialized, thus the plaintiffs have suffered no injury, in fact lack standing. Then he said their ham sandwich, their case, therefore must be dismissed. Look, there is no shortage of videos in which I have actually referred to Southwest and Boeing as an organized crime family at times, especially when it came to the whole MAX mess. But seriously, this case was just a money grab at the expense of those that actually died in the MAX crashes. But hey, like I said, you can sue anybody over anything. But in this case, in my opinion at least, the legal system worked as it should. What about you? What do you think? Let me know down below. Especially if I have any lawyers out there, I'd like to know what you think. Well, that's going to wrap it up for now. As always, on your way out, please be sure to subscribe, like, share, and ring the bell. And remember, leave the rubber on the runway and your troubles on the ground. And I will see you next time in the air. Yeah, this is Maximus.